conference. And we are going to start with the word of prayer from one of us. We did a bit of, should I call it picky ponky with the program, so that we are able to have presentations of some of the people that are already online. So our first presentation today for this session will be done by Dr. Scholastica Omondi, and she'll be looking at assessing the realization of the right to participation in political life for people living with disabilities in Kenya. So if you look at your program, her session is session 13, the first paper in session 13, if you look at your program. The second presenter that we are going to have is Dr. Evans Ogada. So Dr. you can join us in front here. You will be the second presenter after Dr. Omondi's presentation. And Dr. Evans Ogada will be talking about the power of language in the context of adjudication. So he'll be examining the Supreme Court's use of language in the consolidated presidential petition in 2002. So the picky ponkies, the red herrings 2022. So the red herrings, the hot hairs, nakadhalika. The third presenter would be Ronald Kihali. So Ronald, if you're in the room, please come in front. Ronald Kihali will be addressing IBC dysfunctionality, looking at juxtaposing this, the 2022 IBC to the 2017 IBC in the context of the presidential election judgments. So, Ronald, please come. Number 4 for today will be Ambrose Otachi, who will be looking at what election of women means for Kenya. So, Ambrose, welcome to the panel. And I won't ask Prof to come already, but I'll call you when you're ready. So Prof Mbote and Dr. Ruth Aura will be the 5th presentation for today. They'll be looking at the elusive 2/3 gender rule, reflections of the 2022 general election. So these are the papers that we'll have for now, for the morning session. Panelists, it's 10 minutes. And 10 minutes is 10 minutes, not 10 and a quarter or 10 and a half a minute. So please keep to time so that we are able to meet the objectives of the workshop. So if Dr. Omondi is online, Dr. Omondi, if you're ready. Okay. Which is you? So you're presenting on behalf of Dr. Omondi? Yes. Okay. Sorry, just a clarification. Dr. Omondi is joining us online, but Ms. Maragia Josephine is here with us, so she'll be presenting their paper, which is assessing the realization of the right to participation in political life for people living with disabilities in Kenya. So let's welcome her and give her the opportunity to present.
Thank you so much. Thank you so much. Good morning, everyone. It's a privilege to share this platform, and it's a privilege to make a presentation. I want to take this opportunity to thank the organizing team and everybody who's been involved in making this process a success. So as you've been told, I don't know, I had shared the slides. Yes, as they are planning to project, as you've been told, my name is Josephine Maragia. I'm presenting on the realization of the rights of people living with disabilities in participation in political life in Kenya. And my co-presenter is Dr. Scholastica Omondi. She'll join us online kindly. She sent her regards. Please acknowledge them. She's having difficulties, but as we progress, she'll be able to join us online. Yes, it's there.
Tafadhali technical team. Let's just continue.
It's okay.
They'll sort it out as we go.
Thank you. Those are some of the challenges with technology. So we'll start, and then we will, thank you. It's now okay. We can move to introduction, because I already introduced the topic. Our argument, our thesis is based on Article 29 of the Convention on Rights of People with Disabilities. Kindly move to the next slide. Oh, okay. Yes, thank you. So Article 29 of the CRPD guarantees an electoral process that is non-discriminatory while requiring state parties to provide disability-related accommodations for people living with disabilities. The same is echoed by the protocol of the African Charter of Human and People's Rights, and also our Constitution, Article 54 of the Constitution. Even so, you find that the rights of people living with disabilities is yet to be realized, and our focus will be on the voting right. Of course, when we say political rights, you understand that it refers to a number of things that include vying, funding election campaigns, petitioning, and many others. But our focus in this presentation shall be on the right to vote. Why? The right to vote is a fundamental right, and it's fundamental aspect of democracy, enabling people to influence decisions affecting their lives. Yes, it seems, okay, we should just progress. So as I have said, whereas all the aspects of political life are important to people living with disabilities, we shall focus on the right to vote for the reason that I have already stated. The right to vote, exercising the right to vote is more of a process. There are presenters who've been here before, and I agree with them that voting is a process. It starts from pre-election, election stage, and post-election stage. The research methodology is social-legal research conducted by carrying out a desk review of both primary and secondary data and through making qualitative analysis. The theoretical framework is the social constructivism theory, Just in a nutshell, the theory means that the argument therein is that we need to change our focus. The society needs to change the focus from the medical perspective. We stop viewing people living with disabilities as an individual problem. We focus on the environment that surrounds them. You find that so it's a theory that moves away from the medical model and focuses on an impaired individual. So we start interrogating on our environment. The relevance of the theory is that it causes a paradigm shift of the society. Now we stop looking at people living with disabilities as people who have a problem, a medical problem that needs to be fixed, but we start focusing towards having an environment that is accommodative, such that they are able to live their lives like anyone, like any other person. I'll move to the study findings. There are a number of challenges that are associated or that are experienced by people living with disabilities at the 3 stages of election. We have challenges at the pre-election, election stage, as well as challenges at the post-election stage. At the pre-election stage, this is where voter registration takes place, civic education, auditing of the register, and other aspects. So you'll find that, particularly in Kenya, voter education or civic education happens in buildings, particularly schools, and you find that the way our environment is constructed, right from transportation to accessing the buildings, there is no provision for people living with disabilities. For the physically impaired, they will not be able to access. Even when they access, those that have visual and hearing impairments or hard hearing are not able to get the communication that is passed through the civic education. Mostly, you find that there are no alternative methods of communication, and those people lose out in getting the information that they need to get in preparation for voting. There is also lack of alternative methods of registration for people with amputations. We know that in Kenya we have the biometric registration, whereby one is required to use the fingerprints to register. But then we have situations whereby maybe because of an accident or any other eventuality, someone loses an arm. There is no provision for this kind of people. What is supposed to happen for them? In Sierra Leone, they have adopted a system whereby if someone has lost an arm, the hand, then this person is allowed even to use her foot or his foot to register. At the election stage, there are also challenges, many of them, accessibility to information and communication, that one I've already explained, inaccessible buildings, ballot boxes, voting booths. I don't know your experience, we just came from voting, that's the last, was it this year? We voted. I don't know what your experiences were, but my experience was the first point of interaction, there was some list of names placed somewhere very high, and I found the aged just seated nearby. Thank you for the reminder. So you find that people with physical impairment will have problems. The ballot boxes, the voting booths are on a raised platform. There is no provision for people who have physical impairment to access such facilities. There is an example of the case given there by Fiona Given, and it's an Australian case where the Committee on the Implementation of CRPD held that it was an obligation of the state to implement accessibility under Article 9 of the CRPD. Then there's the challenge of discriminative laws, where it is generally thought that people having intellectual challenges have no capacity to make a decision. The case that illustrates well is the case of Nyonkabi, Kanyua, and AG versus another 2010 Kenya law reports, where the court held that the persons of unsound mind were unable to take part in any function that requires the exercise of choice due to their status, since they were not in control of their faculties. Whether that is true or not true, it's debatable. You find that the challenge we have, especially in our legal system, is that there is over-reliance of the medical reports, and there is no procedure outlined in law for challenging once a medic has declared someone incapable or someone having unsound mind. There is no procedure provided in law for challenging this. Then I'll move swiftly to the challenges at the post-election stage. There is particularly one, post-election violence. We find that in Africa, our democracies, we're still growing, we have challenges, and we find that people or the losers will find it difficult to accept the results. So those with physical impairment, of course, post-election violence affects everyone, but people living with disabilities suffer the most of it in terms of their disabilities. There are other challenges that cut across the 3 stages of the election cycle. These are socioeconomic barriers, lack of accurate statistics and poor planning, and inaccessible dispute resolution tribunals as well. The case that illustrates well is the case of Anupa and AG, where the petitioner was not able to access the court building. Mr. Orago is looking at me, Stanley. Just allow me 1 minute to finalize. I'll move swiftly to the suggestions on the way forward. We need to work on the elimination of discriminative laws and aligning the existing laws with the CRPD, provision of alternative voting system, making voter registration, voting, and civic education accessible to people living with disabilities, public sensitization, putting in place stronger monitoring bodies, and having commitment to observing the disability laws, and transformative interpretation of disability laws. Allow me just to say something on the last point, transformative interpretation. The cases that I had highlighted above, there was less recognition of towards the rights of people living with disabilities. But we are having progress from the bench. The case in point is the case of Mora, Siringi, and Republic, where the court gave effect to Article 12.
You can take your seat as we invite the next speaker, Dr. Ogada, who will be looking at the power of language in the context of the Presidential Petition 2022. Daktari, 10 minutes.
Good morning. As my brother prepares to set up the slides, mine is very simple. We're going to look at hot air, wild goose chase, na kadhalika. Authorial license, I have modified my presentation and I've called it the analysis of the Supreme Court managerialism in the context of election petitions. Next slide, where we have the court. This is deliberate for this reason. This is the first constitutional court in South Africa. We call it the Charles Carlson Court. And I chose this court for the reason that this is the first court in the South African context that bore the vision, the transformative vision, and set up the South African court for the feat it has achieved today. They had the intellectual and situational awareness to set up the court on firm foundations. Now, Greek philosopher Socrates posited a quadrant of qualities he identified as necessary in any good judge. What are these values according to Socrates? Hear courteously, to decide impartially, to answer wisely, to consider soberly. Now, law as an effective symbol of any community, its nature and purpose ought to mirror what the Germans call the Volksgeist and the Zeitgeist, the spirit of a people and the times of a people. Language is the medium through which law acts. In its capacity as medium, language of law necessarily has a pervasive effect on a variety of socio, political, and legal dynamics. And whereas it can be said or argued that the provincial of judicial language enjoys considerable latitude in terms of judicial discretion, that discretion is not absolute, it's not untrammeled, at least in the Kenyan context. Professor Willie Mutunga, former Chief Justice and Professor of Law at the University of Kabarak, in a speech on May 31st, the year 2012, making a speech during the launch of the Judiciary Transformation Framework, said this, that the Constitution demands a cultural shift to enable the judiciary lead the transformation of the Kenyan society and to bring it in line with national values. In effect, we were moving, the announcement that Professor Mutunga made was that we were moving from the old judiciary where judges thought of themselves as the Third Reich, the chief with a big stick, and that the courtroom was a classroom and they could bark orders and shout at the rest of us. The Constitution canonized certain norms and values and national principles. And part of those principles are contained in Article 10, and these principles include human dignity. Those provisions should be read in harmony, in harmonia, with the provisions of Article 73.1, whereby the authority granted to a public officer is a public trust. And those who hold public office should bring honor to the nation and dignity to the office that they occupy. Those are the foundational, the undergirding principles according to the Constitution, the shift that we expected. Next slide, please. We go to, next slide, just go, proceed. Yes. Hot air, wild goose chase, fool's errand, worthless pursuit. Do you have the social media? The effects of such uncalculated pronouncement from the court leads to this. If you look at the Twitter handle of the Chief Justice, this is what she's subjected to daily. You will always see this ostrich image against her face, and the barrage of insults are inexplicable. It's painful. And you see, the Chief Justice combines an office, the leadership of an office, and she presents the image of the judiciary. Now, those infamous words uttered on 5th September 2022 and repeated again on the 26th of September continue to have ramifications, as we have all seen. Now, fear and mistrust of language frequently go together with fear and mistrust of law, what is called jurisphobia. Law is the tower that language built. Charles Dickens has, in his novel, The Bleak House, a quote on the context of contentious litigation, whereby advocates involved in exchanges. I'll not read that because of time. What the court should bear is that elections are characterized by rancor and suspicion. And against this background of general mistrust and heated, polarized election contests, the Supreme Court should have been aware of the need to be cautious in terms of the language used in official decision-making. In common law systems, judges are required to carefully explain their reasons. And in explaining your reasons, you ensure fairness in the outcome. This takes us back to Socrates' 4 virtues of a judge: hear courteously, decide impartially, answer and consider soberly. Fully aware of the emotion wrought elections have on national cohesion, the Supreme Court should have been watchful in terms of the language used. How should courts communicate with those before them and indeed the public at large? Language, it must be borne in mind that it's a process of creating relationships among those who jointly engage in it. That is something that was lost on the Supreme Court. Language is often defined as a set of symbols for expressing thoughts or as mechanism for transmitting information. In a context of rancorous election contest, a bitterly argued election petition, the court should be and ought to have been alive to subjective sensitivities that may emanate from the parties and the general public. The court should have walked the middle line. Perception is part of judicial work, and it's not an idle question. Those of us who remember from administrative law, the so-called third rule of natural justice. Lord Justice Hewitt in R versus Sussex Justices ex parte McCarthy, justice must not only be done, but must be seen to be done. That, again, was lost on the Supreme Court. From a perceptive lens, the court has the obligation to satisfy the reasonable person that it was fair, that it bore no animus against any of the parties. I have gone on to look at what is defined as judicial temperament, which I cite the Supreme Court as lacking in the use of the words. The American Bar Association defines temperament as having compassion, open-mindedness, sensitivity, courtesy, patience. That will be seen in the final paper. The court also assails certain values on impartiality. These are values contained in the Bangalore Principle, the Universal Charter of the Judge, this was missed on the Supreme Court. The Latimer House principles, those are there. You will see it in the final paper. The third most important thing that the Supreme Court missed was that language is a social event, not only in the sense that it brings people together in dialogue, but that it ought to have created harmony. It had to have gelled the various facets of the law, the litigants, the public. That is one point that was lost on the law, on the Supreme Court. Now, due to time, I'll say this, that through speaking and listening, we achieve our identity as a legal polity. Collicima ergo sumnus. We speak with each other, therefore we are. The Supreme Court did not have that in mind. The dialectic ingenuity, the court as an exemplar of institutional form is expected to maintain respect for canons and practices of the use of language in court. Past the glitz of power, 2 more minutes, past the glitz of public power, titles, decorum, the bibs, the gowns, and the rarefied ambience of courthouses, judges must be allowed to ensure that the solemnity of the occasion that is required in a judgment is maintained. The responsibility, therefore, for the court is to be sensitive to the solemnity of the roles that they play. Ladies and gentlemen, the South African Constitutional Court, a judge from that court, Justice Albie in the case of Minister for Finance and others versus Van Harden, demonstrates the image of a judge situationally and intellectually aware that the use of language has impact beyond that particular decision. And in the case of Minister of Finance and Van Harden, this is what Justice Sachs said. Thus, I endorse the essential rationale of all judgments, and I explain why I believe that the Constitution obliges us to join together what the judgments have put asunder. Intellectual and situational awareness that the Supreme Court lacked. The Supreme Court failed to heed the foundational frameworks laid by the Mutunga Court in terms of transformation, in terms of judicial culture, in respect of what the Constitution calls for us to do. I end by quoting the book of Colossians 4:6. Let your speech be always with grace, seasoned with salt, that you may know how you ought to answer every man or woman. Thank you.
Thank you so much, Daktari, for hot hair and wild goose chase. The third presenter will be Ronald Kihali, addressing the IBC's dysfunctionality. Karibu, Ronald.
Good morning.
Good morning.
I'm Ronald Kihali, and I'm privileged to stand before you to present this paper. It would appear that this morning we are all criticizing the Supreme Court because I want to do the same thing as my predecessor. And we are not doing it out of fun, but we are doing it because we want to engage and we want to contribute positively to electoral jurisprudence. So I'm not an expert. I mean, I was not on the bench when they were deciding the elections. But I felt that as a student of law, I would give my insights on what I felt after reading the 2022 decision. So I had the privilege of reading the 2022 decision, and I was just making a comparison with the 2017, the Maraga decision, and that informs my title, Juxtaposition of 2022 and 2017 Presidential Election Judgments. And so, what is my central argument? Okay, just before I talk about the central argument, let me just give a brief outline. I'll talk about the central argument of the study, and then I'll skip the role of the IEBC and the role of the Supreme Court because those issues have already been addressed extensively by previous speakers and also in the interest of time. So I'll go straight to examining RILA 2022 and RILA 2017 judgments. I classify RILA 2022 the way it is because he was the petitioner alongside others in the 2022 presidential elections. Just like RILA 2017, he was also the petitioner in that decision, so I just use that term, RILA 2022, RILA 2017. And then I'll be giving the implications and what next for the future, and then I'll conclude. So just to move on to my central argument, basically in this study, what I'm arguing is that after reading the 2022 decision, I was dissatisfied with how the court handled the issue to do with verification and tallying, and especially with regards to the working out of the 4 commissioners. I felt like the court did not address that issue extensively. It trivialized the whole matter, and as I'll be showing, it just called the working out of the 4 commissioners as a last-minute boardroom rapture, which I didn't think was a correct analysis of the whole incident. And so I'll be looking at that and giving my own views, and I'll be inviting people to give me their own views, especially if you've read the 2022 decision. So you can just skip. We can proceed to slide number 6, where I'm now beginning to examine RILA 2022 and RILA 2017. And just a brief look at RILA 2022, you would see that in that decision, the court was very clear that the IEBC can only perform its functions and powers as a collegiate institution, meaning that all its functions and its powers can only be performed as a collective agency and not by the chairperson or by the commissioners themselves. And indeed, that was what was decided at paragraph 221 of the decision, and I was happy that the court was able to affirm that. But the question is, did it apply that rule when it was determining this issue? And my answer is in the negative. And so just to proceed to slide number 9, whereby the court is affirming that Regulation 87 is actually unconstitutional because Regulation 87 of the Elections General Regulations of 2012 purported to give the chairperson exclusive authority to verify and tally results to the exclusion of other commissioners. And indeed, this is what the respondents were arguing, and they were saying that that provision of the law is actually constitutional and there's no problem with it. But the court came out and said that that regulation is unconstitutional. But I asked the question, why wait this long to declare this provision unconstitutional? Because this provision has been in existence since 2012, because these regulations were enacted in 2012. So who knows the forms of election malpractices that have been conducted over these 3 election cycles based on Regulation 87.3, because the court waits until 2022 to declare it unconstitutional. So what about 2017? What about 2013? What if the chairperson of the IEBC or the commission itself as an entity decided to use this regulation to abuse its office? So I asked those questions, and I didn't feel like the court was really interrogating that issue very deeply. And, you know, that is the question I was asking. Why did it take so long for the court to declare this section unconstitutional? And just to move on to paragraph 241 of the decision, the next slide. The next one again. Yes. Paragraph 241 of the decision, I found that to also pose some serious concerns because the court is saying that the timing of the working out of the commissioners was the issue. It calls it an 11th hour denunciation of the election results. And so in my reading of this judgment, I was asking myself, what is more important? Is it the timing of the incident or the rationale for the incident? Because in my view, I would hope that the court would go deeply and analyze why these 4 commissioners came out at Serena Hotel and declined to take ownership of those results, claiming that they were opaque. So why? Why did that happen? So instead, the court took a lot of time to talk about the timing and said, you know, this was just a last-minute thing. This was an afterthought. Why did you wait this long to come and say this? And that's what it says even in the judgment. But I felt like the court should have focused on the reasons for the action. That why did we have these 4 commissioners announcing something different? Why did we have a split screen? Why did we have all this confusion on that date? And rather than just focusing on the timing of the incident. And just to move on to slide number 10, slide number 11, yes, paragraph 242. And I actually decided to quote this paragraph verbatim so that I can just try to give my insights and not be misquoted, because this is what the court was saying at paragraph 242 of Raila 2022. And I'll just read a bit of it. But are we to nullify an election on the basis of a last-minute boardroom rupture, the details of which remain scanty, between the chairperson of the commission and some of its members? In the absence of any evidence of the violation, how can we upset an election in which the people have participated without hindrance, as they made their political choices pursuant to Article 38? To do this would be to subvert the will of the people. It would set a dangerous precedent. And then it finishes by saying, clearly the current dysfunctionality of the commission impugns the state of its corporate governance. So I found a lot of problems with that paragraph for the following reasons. One, the court is saying that it cannot nullify an election based on a last-minute boardroom rupture. I found that to be trivializing the whole issue. I didn't think that the court gave it the urgency and the attention that it deserves, because it seems as if the court was looking at this meeting as any other normal meeting, and not a meeting that was deciding the fate of the elections and the fate of the will of the people. So classifying it as a last-minute boardroom rupture, I didn't expect that from the apex court. I expected that the court would delve deeply into the issue rather than focus on, rather than focus on the timing of this so-called rupture. Number two, the court says that these details were scanty. And well, I leave that to you to determine whether the evidence produced was scanty. But that is not my issue. My issue is, isn't it the duty of the Supreme Court to make sense of scanty details? Isn't it the duty of the Supreme Court to interpret the law? Doesn't that constitute interpretation of the law? That when people present evidence that is scanty, that is unclear, it is the duty of the court to make sense of it and to assuage any fears that the public may have with regards to the confusion that was experienced on the election day. So again, I felt like this was some sort of indolence from the court in deciding that it did not really want to delve into the issues. Again, if you look at the last line of that paragraph 242, the court is saying clearly the current dysfunctionality of the commission impugns the state of its corporate governance, but did not affect the conduct of the election. I found that last line to be not only ironical, but also conflicting. Because if the court is acknowledging that the IEBC is dysfunctional, and it says there clearly at paragraph 242, it acknowledges that the court is dysfunctional, and that in conducting its elections there was some sort of malfeasance. But then it goes ahead and says that this did not in any way affect the conduct of the elections. So here we have an institution which is dysfunctional, as acknowledged by the court, but the court is saying, despite the fact that it was dysfunctional, it did its work to the best of their ability, and it did not affect the conduct of the elections in any way. I mean, I leave that to you to inquire whether you think that last line makes sense, really. I think that is with regards to paragraph 242. And so we can move to Raila 2017, which is slide number 15. Yes, Raila 2017, this is basically just the Maraga decision that nullified the elections, and I used it as a best practice because I felt like this decision really analyzed the issue of the conduct of the elections by IEBC in a manner that contributes positively to electoral jurisprudence. For example, if you look at just the first paragraph there, the court was referring to the Kriegler report. Just 2 minutes to add, please, thank you. The court was referring to the Kriegler report. And as we all know, the Kriegler report came in the wake of the 2007-2008 post-election violence, which was basically just giving an outline and a highlight of the sort of election malpractices that happened in the 2007-2008 post-election violence. And in referring to the Kriegler report, the court says that counting and tallying during the 27th to 30th of December 2007 and the announcement of the individual results was so confused and so confusing that many Kenyans lost whatever confidence they might have had in the results. And so I found this to be a very progressive provision because it means that the moment you have any sort of confusion, then the Supreme Court must cast doubt on the integrity of the electoral process. And I'm sure we all experienced confusion on that day because we were all seeing a split screen and we were wondering what is happening. But according to the court, that was just a mere last-minute boardroom rapture, and it did not in any way affect the conduct of the elections. And if you proceed to the next slide, again, the court is saying at paragraph 292 of RILA 2017 that the duty to verify and tally must be done in consultation with the chairperson. And with regards to the 2022 elections, I think it's clear. The key takeaway is that there were literally no consultations. We don't know what happened, but we know that they did not consult because they had differing views. And so we can allude to paragraph 292 of RILA 2017 just to show us that in terms of the Supreme Court delivering its judgment, it must examine, it must interrogate were there consultations between the chairperson and the IEBs and the commissioners, including the staff of the commission. Because of time, my time is actually up. I'll just proceed to talk about what next for the future. And, you know, basically, this paper, when I did it, I realized that the Supreme Court has a fundamental role in promoting access to justice during the democracy. And it has to make sure that in delivering its judgments, it does so in a manner that contributes positively to our electoral jurisprudence. It must interrogate those issues deeply and in a wider scope, and not just look at issues superficially. And this would also entail promoting independence of the judiciary. That means that they must be able to conduct, they must be able to deliver their judgments in a manner that is without fear and favor, and looking at the issues rather than just the formalities. And so I think that was the gist of my paper. It is still in progress, but I'll invite a discussion on this, especially if you have gone through the decision. Thank you so much.
Thank you, Ronald. Applause to Ronald. Our next speaker is Ambrose Otachi. Ambrose, welcome. Ten minutes.
Okay. Thank you. Good morning, everyone. My name is Ambrose Otachi. I work with the Institute of Election Science and Research as a researcher. We focus on building grassroots movements across the county, in counties across the country, and supporting people to bring change to their own communities. Without much further ado, I welcome my boss, who is going to discuss our abstract. Edward.
Good morning, folks. As we wait for the paper to be uploaded, I came here yesterday, and so I've not been following the proceedings, but from the presentations of today, I think they have been well to do. An analysis of the Supreme Court. My name is Edward Kusawa. I teach economics and other things, St. Paul's University and other places, and I'm glad. So my presentation actually was supposed to be done by a lady, one of the students who would have been a good presenter for this topic, not necessarily men, but the students, I think, we are still training them on public speaking. And so what election means for Kenya, let's move on. For women in Kenya, let's move on. That's the Guardian. Kenya elections brings new wave of female leaders to the fore. This is something that most people have been able to see. We are especially grateful, and maybe the question has been, why is it that more women are participating in current elections? That is something that we'll be able to see. Let's move on. These are the trends. Why didn't we reach where we are currently? Because this is when the new constitution comes into force. So you can see from 1963, representation was actually nil. But as we come to 2013, I think the regimes that were there before were not able to give women the kind of conducive environment for them to be able to